Good evening to all of you. My name is Raj Kumar. I'm the founding Vice Chancellor of OP Jindal Global University. We're very delighted to welcome all of you to this Corporate General Council's Colloquium on the theme Law and the Future of Business Responding to Risks, Regulation and Compliance. I have with me a very distinguished set of colleagues and friends who have represented and indeed excelled in their respective careers as lawyers. I will be introducing them shortly. Before I do that, a brief introduction to the theme of this evening's colloquium. COVID-19 has overnight paralyzed organizations across the world. As supply chains got disrupted and countries went into lockdown, businesses experienced a never-seen-before shutdown. With a population of over 1 billion people, the need to be in lockdown was critical for India, the largest democracy in the world, whose global health security index is merely 46.5 out of a possible 100. This crisis has not only weighed on consumer consumption of goods, but also led to sluggish business operations and a sharp decline in India's economic growth. From loss of employment to wage cuts, the coronavirus is omnipresent in different forms across organizations' households. What started as a health crisis has gradually but surely escalated into a crisis of different proportions, including affecting essential services operations. In fact, organizations have found themselves exposed to health risks as well. Some organizations are able to embrace technology to continue working from home and to deal with risks associated with remote operations. And unfortunately, some organizations will perhaps never see the light of the day. With the dire need to rebuild our economy as lockdowns get partial released, companies have begun to resume physical operations and production, while some continue in the work from home mode. Irrespective of the modus operandi, it is clear there will be a new set of norms we will have to adhere to and revised and indeed progressive set of regulatory requirements on various aspects ranging from salary payments to data privacy, contract settlement, and health safety infrastructure. A recent report by Ernst & Young identified that 100 plus countries have issued 350 regulatory notifications to deal with COVID-19. Also, 150 plus compliance obligations may arise because of the pandemic. Legal counsels of companies will need to very quickly adapt to the new requirements to ensure that there's a fine balance between risk mitigation and governance. The crisis we face today is not ordinary and will require extraordinary efforts to ensure law and also other forms of predictability in businesses continued. While this is indeed the most unprecedented crisis of our times, it's also an opportunity to reinvent ourselves to strengthen the future. Law can bring order to this state of chaos, and we must identify measures which are not only innovative, but also sustainable. Therefore, this colloquium is an important platform to discuss how organizations should respond to risk, regulation, and compliance to strengthen and define the law and the future of business. I have great pleasure in welcoming a very distinguished set of general counsels. Let me begin by Mr. Shashwata Dutt, who is the Executive Vice President and Country Counsel of Vodafone Limited. He is indeed a very resourceful and skilled lawyer, having experience for nearly 25 years of in-house corporate legal exposures in diversified business. Over the course of his career, Mr. Dutt has developed expertise in multiple sectors such as fast-moving consumer goods, chemicals and fertilizers, telecom, financial services, e-commerce, retail, and many other sectors. In addition to sector-specific capabilities in the form of laws, he has developed keen interest in the specialized and emerging laws such as competition law, indirect taxes, and privacy laws. Thank you, Mr. Dutt, for joining us. Unfortunately, Ms. Payal Khanna is not able to join us due to a bereavement in the family and has expressed her regrets for that. I have great pleasure in welcoming Mr. Shiva Mandal, who is the Group General Counsel of Tata Sons, one of India's largest conglomerates. Mr. Mandal has over nearly 20 years of legal experience and has a specialty in advising major multinationals, private equity firms, and Fortune 500 companies in corporate legal strategy, M&A, deal structuring, and securities law. Mr. Mandal occupies a distinguished position in India's in-house legal arena and is well known and highly respected among peers. Shiva holds LLB from the National Law School of India, University of Bangalore. He has also attended an M&A program at the Wharton School, University of Pennsylvania. Shiva was also the managing partner of Fox Mandal and Associates. Welcome to this program, Mr. Mandal. I have with me Mr. Mohit Shukla, who is the Managing Director and Head of Legal and Compliance for India at Barclays. In this role, he is responsible for the general oversight of legal and compliance services to all the Indian businesses and Barclays entities and for general legal and compliance risk management in India. Prior to joining Barclays in 2010, he was with Citibank for 9 years as Citi's country general counsel for South Asia, covering India, Bangladesh, Sri Lanka, and Nepal for all of Citi's commercial businesses and also its technology support arms. He has over 20 years of work ex with a diverse background, including metals manufacturing, tobacco, and hospitality industries prior to financial services. Mr. Shukla's video is not working. He will be joining us through an audio system. Thank you, Mohit, for joining us. We have with us Mr. Amar Sundaram, who is the India Head, Legal Governance and Regulatory Affairs at the Royal Bank of Scotland. Mr. Sundaram is an in-house senior corporate legal professional having 20 years of rich experience, formulation of operational guidelines, and a business enabler to complex legal issues. He has worked with the best of the Indian and multinational business houses like DCM Shriram, Birla, Tata, AT&T, Reliance, Citi, and Ernst & Young. Amar was declared as the best general counsel in 2019 by Indian National Bar Association. Thank you very much, Mr. Sundaram, for joining us. All right, thank you to all of you for being here. Let me begin with Shiva. As organizations slowly resume business operations, it is clear that businesses won't be able to achieve the pre-corona type situations, both in terms of productivity, but also other aspirations. And they need to recalibrate their governance to new guidelines and regulations. How has COVID-19 affected your own organization, but also broadly your own industry? How is the risk landscape different for businesses in developing economies? What kind of legal and business-related risk analysis should firms engage in to identify potential compliance and regulatory risks resulting from COVID-19?
Thanks, Raj. Hi to everybody. I think, Raj, you've rightly identified the risk that COVID-19 brings about. But, organizationally, I would like to just say there are kind of two risks that we believe are kind of more heightened. The first one being, I think there's an increased counterparty risk most organizations are facing. So naturally, the counterparty risk means you start putting in your own internal measures to either deal with that counterparty risk or to kind of put measures which would prevent that counterparty risk getting accelerated. So these are mainly in performance of contracts. That's like to just kind of give a key. For a lot of the lending institutions, some of our lending businesses, it's got to do with what's going to be the payouts in future. So I think that's one big risk, that counterparty risk that has come up. I think the second big risk, which I think will be interesting to talk about and see the experiences, there is going to be more internal risk coming up. And when I mean by that internal risk is there is a tendency or an inclination, if you may say, to kind of cut corners, or there could be a situation where people take views or judgment calls, which would be closer to the line than before. And that happens both internally and that happens with the counterparty. And that kind of triggers a very interesting situation where I think we will kind of discuss as it evolves is, if you see the experience post 2008, the regulators across the world, and my colleagues from the banking industry, both Mohit and Amar, will be able to throw more light on that, is they got into a mode of revenue collection. And I'm not saying, we're going to see, we necessarily will see that in India, but I think there is the risk where there is going to be more higher scrutiny from governments, because increasingly compliance at the government's end has also become about a revenue exercise.
Thank you very much, Shiva, for setting the stage for this conversation. Let me move to Amar. Amar, building on what Shiva briefly alluded to, as some organizations resume their operations and even production, of course, in your industry, it's a bit different. How much does the role of in-house legal counsels like you and others need to be redefined. To what extent this is going to generate a new world of compliance requirements, ranging from the physical health and safety to payment of salaries, especially for employees unable to work under with limitations. What are the whole HR implications which will then be brought into a compliance framework when it comes to office contracts, just during but also post COVID? How do you deal with potential, let's say, tort liability type issues that can COVID-19 create? Is the general counsel office suddenly become more important than it ever was before?
Thank you, Rajiv, for such a wonderful question, and very appropriate considering the time in which we are. So, Indian legal system and the corporate system, by and large, were not attuned to the kind of situation we are in. This is an unprecedented situation. We are 90 days or 95 days now. It's evolving. Risks are being analyzed. New problems are being witnessed, which was not witnessed so far. And therefore, many of the things which we are seeing today is not something which was envisaged earlier. What Shubha said is absolutely correct. I'll just like to add two more regulatory risks that industries are facing. One is the increase in the financial crimes, right? And especially in the financial sector, we are seeing a lot of increase in the financial crime. Cyber attacks are happening purely from consulting firm where I worked earlier. There is a lot of issues around breach of confidentialities. Now, client confidentialities were very, very important, and it is at the bottom of many of the contracts. Now, those breach of contracts, breach of confidentiality is something that we are witnessing and we are going to witness. Employee salaries, we were all fighting and trying to understand whether during the lockdown period wages are required to be paid or not to be paid. And on 12th of June, Supreme Court gave some guidelines and said that when the government of India filed their counter affidavit and said that the notifications which they had issued, and especially the 12th March letter which was issued by the principal secretary to all the chief secretaries saying that no wages should be deducted during the lockdown period. And that created a whole lot of controversies. And ultimately, the government said that effective 17th of May, they have withdrawn the earlier notification, meaning thereby that people can now go back and take decisions as per the contractual terms. But Supreme Court at the end definitely said that the balance between workers and the industry is required to be maintained. And then they said that even for that 50 days of the lockdown period, if there are any issues regarding wages, that should be amicably settled between employer and employee. And if there are issues, then the government can intervene. So many of these issues are cropping up. There are issues relating to furloughs. So some of the organizations have forcefully sent their employees on a leave. Some of the organizations have terminated their employees. Some of the organizations have shut down their businesses. Some of the organizations have slashed down the salaries. But end of the day, many organizations have done it through a mutual negotiation and settlements. Now, these are the issues which are going to haunt. And as general counsels, when we come out of this COVID situation, we'll go back and look into these issues and try to frame the policies, the contracts, keeping these issues in mind.
Thank you very much, Amar, for that. Let me move to Mohit. Mohit, so you, of course, your own industry has its own set of applications. But let me ask you, what are your views on the various, let's say, temporary short-term compliance relaxations given by SEBI and Minister of Corporate Affairs? What kind of regulatory flexibility do organizations further streak to strike a balance between business continuity and legal compliance? Is the government, despite its good intentions, is at best playing a catch-up? Are we falling short of what we really need to be doing? Also, as organizations collaborate to advance economic recovery during the pandemic, what should they keep in mind to ensure continued compliance with various aspects of law?
Thank you, sir. So I think that's an interesting question in terms of whether it's going to be catch-up or whether it's going to be proactive from a regulatory and a government point of view. We had an interesting conversation at some levels at the regulatory and government, centers of power, as you will, in terms of precisely this question not very long ago. I think the most interesting element of that conversation essentially centered around the fact that when you look at the canvas of this pandemic and what it has brought to bear in terms of the fine balance between how do you canvas business, how do you transact, how do you bring about some amount of economic activity and revival and continuum in that space, even as you deal with the wider impact that this has had, both in terms of making sure that to the best possible level, people can be kept safe, and also dealing with the wider socioeconomic issues that have emerged in terms of migrant labor movement and how to deal with mass-scale disruption. I think the interesting element that came out from the government was it will be reactive for a certain point of time because it is just so large. And that's completely understandable. When you look back at what the government and the regulators have sought to do over the last 3 months, is basically react as fast as they can to what has possibly been the most elemental, urgent issues and aspects that have come up in deliberations and in terms of just what to do with respect to stimulus, what to do with respect to easing things. And it's not been an easy time for both government and regulatory spaces as well, given that it's not only the COVID-19 situation that has impacted us, but you've had several other things which have distracted people, be it natural disasters, be it hostilities, be it tensions of various kinds, trade issues, sanctions, what you will. So juggling that whole, panoply of things has not been easy. But that said, if you look at what they've done in terms of addressing sectoral issues, be it MSME, be it in terms of SEBI listing requirements, be it how distressed debt can be dealt with, within a particular time frame, given what the MCA has done in terms of relaxations, in terms of processes for board meetings, as an example, given what Reserve Bank of India has come with, through a series of measures for the market and for the banking and non-banking finance industry, you'll see that they've done things, but obviously, from an industry point of view, nothing is ever enough. And the response from the government basically is like, you will never be satisfied because at some point of the other, there's somebody looking for something specific for themselves. But at the end of the day, we can do this much. So one question, I think, from the point of view that you raised in terms of last mile coordination, in terms of things that the government relaxes or regulators look at. And what I think one of the most important things that has surfaced is last mile coordination and how it comes to bear at the operational level in terms of how do you implement it. For example, and this dovetails very, very neatly with business continuity procedures that business houses have had to implement. And it's surprising, sir, when you look at business continuity procedure, you'd think there's a one-size-fits-all framework for an organization. We've discovered in practice that you've actually had to look at business continuity procedures for each line of business, for each product, whether it's for transactions, whether it's for contracts, what have you. And in terms of what the government has relaxed, what the regulators have relaxed, and what last-mile coordination hitches may be, when you look at BCP, that's where it dovetails in terms of being able to actually bring that to fruition and bring that to bear. The good thing is that through industry associations, through one-on-one dialogues, regulators and government have both been very receptive. And therefore, it is work in progress, but I think a substantial amount of work has been done towards making things easy from the perspective of relaxations. The fun will start when things have to go back to normal and people have to take stock of what they've done in terms of the relaxations and how do you make sure that you bring it all back to a regularized process and make sure your housekeeping is neat, your documents and your records are clear, and what you've done in an exception process must not continue to leak on, and you need to bring things back to normalcy. that's where the fun will start.
Well, thank you, Mohit, for a very comprehensive response, and we're going to take on some of those issues. We are live on Facebook and YouTube for all the viewers. Let me encourage you to send in your questions. At the end of the first segment of this program, we will take up questions from our audience as well. Let me move to Saswata. Saswata, the work from home could be one of the lasting takeaways of this global business lockdown. What are the best practices for companies to strengthen continued compliance in a remote work environment with the regulatory frameworks to be complied with across multiple jurisdictions? How challenging it is to implement these kind of practices in organizations as large as yours, for example?
Thanks, Raj. I think it's a very topical question to address. I think work from home will be the new normal, in my view, and many industries are actually thinking how to, align with this kind of ways of working in the future days to come. One of the point which as a telecom company is that it increases productivity to some extent. In terms of it's a virtual meeting. Within a short time, people can assemble in the group and you can deliberate and come out with a definitive solution. That's one part of it. But the risk, when you say, I think one of the key risks which I think we need to keep in mind is the confidentiality and data security. And in the current circumstances, suddenly when you are forced to work with work from home environment, probably all the organization may not have actually gone into VPN secured kind of connection. Those who are in financial business or telecom business who had some kind of infrastructure and data security in place, probably it was easy for them. But those who are not, that is a bit of a challenge. Coming back to confidentiality, I think whether it is an interparty contract, as Amar has rightly pointed out, is that the maintaining the confidentiality so far as the business partner's data is concerned is, I think, utmost important. So does the customer data, because when we talk on call or phone relating to any particular specific issue, I think customer data is also becoming a particular area where we need to keep in mind. I think how to bring these kind of issues in a discussion table and educate the people, I think that is something is very important. And let me tell you what we are doing. All leaders in their respective verticals are trying to address the need of the confidentiality, reinforcing the need of confidentiality and data security on a regular basis. And we are explaining to them that the precautions which they are to make, the areas of vulnerability and exposure. And we are making analysis in terms of all verticals, because if we talk about supply chain, there will be an interface with the external vendors where there will be an issue and exposure when you are sharing data outside of the organization. Similarly, when you talk HR, there are issues of medical records and other thing which is very sensitive personal information that has also to be maintained. So what we are doing in the process is that we are educating them, and we are having very capsule training program targeted for each vertical, where we are giving examples not only from India but from global experiences to say that, look, this issue has come, say in Spain, where one of our what is called supplier had got into a problem, and how the medical report when it went out, how is the issue comes out. So those are the examples which we are giving. And the last but not the least is that we are ensuring compliance in terms of zero tolerance level, and in all communication we are saying it's absolutely non-negotiable. And in certain cases when people are dealing with very confidential thing, because projects goes on, as you know, in a business scenario, in times when you are under pressure and you need to grow organically. In that sense, in organic growth, certain projects goes on, and we are getting special confidentiality agreements signed, executed digitally with a set of project team to ensure that confidentiality is maintained. So I think these are 3-4 things where we are following, how to educate and then ensure the compliance part of it.
Thank you very much.
Raji, I'd just like to
Please
come here. There's a very important topic which is being discussed across all industries and everywhere, work from home. So some data that I have gathered, ITS industry in India employs 4.36 million people. And NASSCOM has come with a data saying that 60% of the IT industry in next 3 to 5 years will be working from home. 40% of the current workforce in next 3 to 5 years will be working from home. So that is the level that we are talking about. Gartner has come out with a data saying that 30% of the people will be across the globe will be working from home by 2030. Now that is the level that we are talking about. And therefore, there is a need that the government today take clue from this situation, come out with a very comprehensive policy around work from home. And then every aspect of work from home should be addressed into that comprehensive policy.
Thank you, Amar. We will take up that as well shortly. Shua, literally, I think in 2006, Clive Humby, British mathematician and entrepreneur, famously observed, data is the new oil. Whether it is work from home or physical offices, data privacy and issues relating to data is going to be critical. With exposure to sensitive data from home offices in various sectors, especially BFSI, but also other sectors, what compliance risks do you anticipate in data privacy compliance alone? A large organization like the one which you are part of, but also others, how do we deal with data breaches, but possibly compliance considerations, not only within the sector, but also even beyond the sector, wherein one's organizational, let's say, reach will be there? How data protection and data privacy is going to matter in the future?
Okay. Thanks, Raj. It's ironic we call data as the new oil when oil is not doing too well, actually.
That's what he said 15 years ago.
So anyway, it's interesting. I've been hearing this whole security and data. I would like to simplify it. I think the issue around data privacy is actually not a data privacy question. So let me explain this. Data has been out of workplaces for years. If I take the last 20 years, take all of us on this panel, we all take work home. If you open my bag, you'll see some papers out there. I'm sure Shashwat's bag will have those papers, some other papers. So it's not that data has not left offices. It's always left. You see people working in airports. You see people working in airplanes. I think the question which you're probably asking is, there has to be a retraining of, you may say, employee behavior or employee conduct in a particular way. And so the fact that employees carry sensitive data with them is not uncommon. People take their calls in the dining table for long. So I don't see any specific challenge. Of course, don't get me wrong. It requires a little bit more repurposing, a little bit more retraining, because you're not spending those 8 to 10 hours at workplaces, but you are spending those 8 to 10 hours at home. And it is not to say, I actually don't think it's such a big issue, because it is not to say that the workplaces didn't have their own data challenges. There were cross teams. You had higher data leakages because there were more people who came to know what you were dealing with versus now. I mean, curiously, like Shashwat referred to, I personally feel there are several items where we are working, which is much where it's much quieter within the organization, if you may say, as compared to if I was right now in office dealing with those topics. So you're right to say there has to be a behavioral change. There has to be employee retraining and repurposing on this point. But I don't think that'll take too long. That is, but what Amarji also said is correct. All these things will happen. And I think in the next 12 months, we'll be ready to roll this.
Thank you so much, Shua. Amar, let me take that question to you. I think Shua has raised a very important point, building on what he said, but also I think increasingly the disclosure norms around the world have also changed. What used to be seen as important, even proprietary confidential information, is more and more expected to be shared in different stakeholders as well. But one of the big challenges relating data is not so much about the fact that there's a breach of data, but the possibility for data to be commercially, created and sold and disseminated, distributed beyond the very purpose for which it might have been actually created. How do you respond to that type of compliance issue where the the commercial aspect dominates the data, not just breach, but even data transfers?
Very pertinent question, Rajiv. And data is something which is, I was talking to the general counsel of one of the leading software companies across the globe today. And the person was telling me that so much of data are getting loaded on cloud during this COVID situation that definitely there are a lot of concerns around the leakages of these data. Mindset, as Shubha rightly said, mindset is something which is at the bottom of any kind of a leakage. And therefore, the employee's mindset and ethics and integrities are paramount. There is no doubt about that. But this is a time when the new data privacy bill, which is pending with the parliament, should be relooked. And some of the issues relating to these data leakages, the sensitive information, the price sensitive information, all these issues should be looked into afresh. Data processor, data controller, these are terminologies which are defined in the laws, which are coming up from the GDPR. And there are a whole set of regulatory regime and regulatory protections which is made out. The real concern that is being faced by Indian judiciary today is how much of these data are moving out of the country and whether they are being stored in Indian server or they are being stored outside the India servers, and how sensitive those informations are. So data is going to be the in thing, and data is going to trouble all of us unless as organizations we make our information security system very, very strong. We coach our employees regarding what Shubha said, the ethics and integrity around building up the data and maintaining data privacy and the confidentiality.
Thank you so much.
I would like to just comment on that. I think I'd like to demystify a little bit of this data discussion. And, I think let us understand what is it at the heart of it. The fact that we're using more of the information technology infrastructure is given, right? We can come up with a system that every time you use an email, you pay $1, right? We don't have that system. So there are two sides to this coin. Inherently, as consumers, we are taking advantage of this information technology world. Now, it's free. You're not paying for it. So what do you pay with it? So data is that trade-off. Now, the question is, take Vodafone, take RPS, the names in this call. The fact that Vodafone is sitting with 200 million customer data is sensitive. I have no doubt. But what makes it sensitive is when you have that data linked to a specific customer. But for Vodafone to trade on the data, to which says we have 200 million customers, of which age profile of 18 to 20 is 5 million. Age profile 22 to 30 is another 15 million. How many are men? How many are women? How many are rural, urban? I don't see why is there data privacy around that. So I think we have to, at the heart of it, understand the data privacy argument goes away when you anonymize the data. When you use the data, as you said, as a commercial construct. If it's not relatable to me, why do I care what Vodafone does with that data?
Yeah. Well, Shubha, I think that's a fantastic point. One of the things that's happening, I'm sure, which you're familiar with, is that Europeans are having a very different framework with regard to data regulation. And I think there is a big discussion and debate happening around the world in this matter. And India is probably beginning to enter into this discussion. And I think we need to be very conscious of some of the issues that both of you have raised when it comes to how we position our own policies surrounding the future. And frankly speaking, regulatory, let's say inappropriate and not well thought out regulatory barriers will only complicate matters, let alone create any sense of data privacy or security for that matter. All right, let me move to Mohit. Mohit, as this comforting conceit that the state of lockdown is temporary phase and supply chains continue to get disrupted and commercial disputes are on the horizon, how long will force majeure protect organizations? In the event of a disagreement about responsibility laws, what is the most efficient way to resolve disagreements? Will negotiation be the new litigation? Do you see a greater acceptance of arbitration and other forms of ADR coming in? Will this result in changes to the pandemic era contracts, especially on areas such as times of the essence clauses or drop dead dates? What do you foresee the future of the very framework of business contracts?
I think that's a very interesting question, and I mean, I can map it to a recent discussion that I was having with a bunch of people across organizations with respect to, if today somebody is looking to transact commercially, what assurances are you going to seek contractually in terms of the fact that, you know, various pandemic-related disruptions are not going to be pleaded to or raised in the event that there is a default, what assurances can one logically and reasonably build into contracts to isolate from this particular situation in its particular time frame, to say that, you know, nobody will resort to arguments that the default was related to this, unless, of course, you have very concrete evidence. And, all of us will have seen some of the things that the regulators and the government have thought about. Some of it has also, kicked up a fair amount of controversy in terms of how it's being interpreted and how it's panning out in terms of, interpretation. You take, for example, the moratorium that the banking regulator provided, and how much debate it has stirred up, both in terms of judicial intervention, arguments in courts, bilateral parley in terms of what it means and what it doesn't mean, and why should X be excluded and why should Y be included. It has kicked up a fair amount of controversy in itself in terms of just how policies have to be framed under regulatory expectations by banking institutions, for example, in terms of what's excluded, what's included, and how much discretion people had in terms of being able to exclude or include in terms of policy-related parameters. So it took its time to settle down, and it's not yet fully settled down. But I think if the extended moratorium does end as of the 31st of August, we're going to see a fair amount of activity after that in terms of where things pan out, in terms of who's being able to perform, who's not being able to perform, and how much negotiation, to your point, will exactly then center around that. Because commercially, if you look at issues like these, I don't think in the short term it's going to lead to a lot of argument or decisioning in terms of what changes need to be brought about in the Contract Act, for example. But exactly in the short term, maybe the next 6 months after August the 31st in this particular moratorium issue, people will be looking to see what do we arrive at amicably in terms of a negotiated position, to see where we land over the next 6 months, the 1 year. And then, interestingly, what is going to lead to is a tightening of contractual frameworks, because people will immediately want to risk mitigate in terms of contractual frameworks, risk policies associated with transactions, to see what needs to be clarified, what needs to be made more clear. And that, I think, is going to be the focus, at least in the sector that I look at. The other interesting element that has come out is the IBC ordinance, which had the very curious proviso which said, you will never, ever take this into an insolvency. And what does never, ever mean? It never, ever means various things to various people. So there's joy, right, in terms of, does it mean that you have to read the whole preamble associated with the proviso to Section 10A and say, no, it only associates with something which is directly, causably linkable to COVID-19 distress? Or is it pretty much open season for you to do whatever you wish and then say, you can't take me to insolvency? And if you can't take an institution to insolvency for whatever happens in the course of this never ever, what do? You, perforce, willy-nilly will be looking at negotiation more than anything else, because otherwise you have recourse to recovery proceedings, you have recourse to enforcement of security if there's security, but otherwise, what else is staring you in the face in terms of practicality? The commerciality of it leads to negotiation. And I think, therefore, mediation, to the point that you made, arbitration, if you don't have an arbitration contract, will you be looking to negotiate an arbitration contract into your existing contract? Will you be asking for people to voluntarily submit to mediation, or will you just negotiate? So I think in terms of the immediate fallout after COVID-19 sort of becomes a little more muted, but is not gone. This is going to be pretty much the environment that most people will be looking at in terms of what's the best case from a negotiated settlement, which keeps you happy.
Thank you very much, Mohit, for that. Saswata, let me ask you this question. I mean, one of the things that Mohit did reflect about is at the heart of it is the role of the general counsel, but also the development of a compliance culture. As part of a large company which has global operations, how do you deal with differences in the way the role of laws and legal system and even legal culture prevails in different places? I mean, how does a company like yours communicate to its employees a tone from the top on maintaining a strong compliance culture and expect employees even during this time to be part of that? And how do you deal with, or to what extent legal audits become important now more than ever before, and how your office does respond to these challenges?
Thank you, Raj. I think it is in continuation of the earlier question where Mohit has responded that settlement probably would be the day, to come. Now, in that context, I would like to give my personal thought on the force majeure, and then I will take it further to the compliance part of it. See, the force majeure, when we talk about in law or in otherwise in a normal circumstances, one party is prevented from carrying out his obligation due to reason which he is impacted. In the present situation, I think both parties are impacted. So coming from that point, I think we need to be equitable in our approach and then take it further in a commercially negotiated settlement. Mere incapacity to pay obviously cannot be a reason for just getting out of the contract. But genuinely, if there is an issue, health or otherwise, which prevented the performance of the contract, I think what we can certainly look at a long-term negotiated settlement where the commercial terms are looked at a longer period of time, where both parties survive in the business. That should be the way forward, because we are not in litigation business. All GCs are doing their respective business in finance or manufacturing or otherwise. Now, if that be the yardstick, now how to progress on the compliance? Coming back to your question, I think there are 2 or 3 elements in that particular question we should look at. When I talk about compliance, obviously the first part, as Subha has mentioned in his initial answer, that there is a tendency to cut corners. Now, that is something which happens normally when people want to meet the target of certain sales or otherwise. That is one part of it. Second part of it, that under any contract, under SLA, there are certain guidelines and norms which are to be adhered to. The party may not meet that and try to, pass on the goods which are services which are not of the quality. Now, how to monitor that? I think one of the ways we should look at is the implementation of artificial intelligence or machine learning to actually monitor the contract SLAs and terms. When we talk about contract lifecycle management, we normally say whether the contract is renewed or extended. Those are the things. Very rarely the business teams, what I've seen in my experience, will actually look at the SLA breach in the normal circumstances. So if you apply technology and identify the SLA breaches or any other breach in the terms of the contract, including the compliance. Now, when I talk about compliance in normally any contracts, we say that ensuring the compliance, legal or regulatory, will be the other party's responsibility if you're providing. Let us talk about child labor. Let us talk about payment of wages. These are obligations which are costed on the supplier side. Now, whether he is doing that or not, nobody knows. We may have received notices. Many of us, maybe when the service provider actually not paid or terminated, probably the labor authorities have written to you as a principal employer or recipient of a service. So those are the situations when it comes. I think while deciding the compliance norms and tone from the top, we need to have IT-enabled system which should capture all aspects. I think what we need to look at a governance, risk management, and compliance system which should be having IT-enabled platform where all the compliance norms are to be put and everybody can access on a real-time basis to know that what are the obligation. And when you do it, you can actually do it your vertical wise or your department wise, commercial, finance, what I told earlier also. The risk mapping has to be done. Then accordingly, the compliance norms to be put and there has to be periodic audit. When you talk about audit, in these situations, it is very difficult because offices are shut, manufacturing units are not operating in its full capacity. So how you will do the carry out the legal audit? One obviously can be positive assurance statement, which you can ask from the respective senior leadership team, so that they will actually get it from their respective team members to say that whatever the platform depicts in terms of compliance of that particular vertical is actually carried out and done. That's one part of it. The second part of it, I think what we need to do is the consistent risk analysis, mapping, and mitigation plan. Because business continuity, in my view, is the key in this current context. So to ensure that all elements are to be seen in a 360-degree approach, and we need to actually ensure that all verticals are ensuring compliance in its fullest term. When you talk about tone from the top, yes, that's given thing. Even in the normal circumstances, large organization like us who has contracts with different parties originating from different jurisdictions, be it US or UK or for that matter, Europe or China, there are issues which will be coming up in terms of the compliance, and hence the positive assurance, what I mentioned, that is also required from the business partners also to say that yes, they are in full compliance. And probably in that IT-enabled platform, both the partners as well as the internal stakeholders can put their compliance norms and status to understand, to make the senior management understand what is the current position and the gap. So in nutshell, I think what should I say, that the strategy for compliance can be exclusive at the top, but when it comes compliance operationalizing, it has to be inclusive. Everybody has to be party to such process, otherwise it's not going to happen, particularly in a situation when you are not under one roof.
Thank you, Saswata, for that. Let me move to Shiva. Shiva, this is a bit personal as well as connected to the issue. Personal because I'm going to ask you a question about, is this about reimagination of the office of the General Counsel? I remember some years ago, somebody like you moved from a corporate law firm into a legal counsel, general counsel position for a major Indian multinational corporation. And this expansion of the General Counsel's office in companies is a very steady but a sure expansion. So the first is this about reimagination? And second, equally important is that how will this impact the work of that office of general counsel? To what extent legal professionals in organizations need to adapt to this constantly evolving requirements of a dynamic regulatory landscape, which is not only about deals, but also constant compliance?
Yeah, so I think when you speak about the reimagination part, I think what and this trend was happening. I don't think the pandemic has changed anything, but let me tell you what the pandemic has done. It has accelerated things. So let's assume the pandemic did not happen. A lot of the things we are discussing today would have seen fruition around 2025, 26. I think what the pandemic does is accelerates things to 21. So that's my first point. Second point, I think where the reimagination has to happen is a massive shift to technology. And this is not just for the general counsels of Indian corporates, but I think globally. Be it the entire legal industry has been, if you may say, 2 steps behind what the rest of the world has been doing in the digital side. When I see the folks in brand teams, marketing teams, or even operating teams, they're far more digital in their way they work than legal teams. And I think that has to change faster than ever. So what has changed? So take for compliance, I think, I mean, we were doing this, but I think I've got a better reason to do it now. To push compliance totally on platforms. So I think gone are the days when you would, collect compliance issues, or you would, reactively deal with compliance. So I think what we are trying to at least build out with some of the service providers is to get into a compliance platform, digitally operated, where I'm not saying these platforms eliminate the issues, but I think they minimize the issues. So, and that also builds into the culture of the organization, which Shashwat said is very critical. Culturally, people need to adopt it. I think the reason compliance has not really, it's a very morbid way I'm going to put it, but the reason compliance has not hit Indian companies yet so hard, other than a few specific sectors, is a function of what has been the scope of penalties. So when you talk to the people in the pharma business, they take compliance very differently, because you have US FDA guys walk into their offices at 7 a.m. When you talk to the banking people like Amar, Mohit, they have a different view of compliance, because globally their peers and the organizations have gone through a lot of turmoil in the last decade to where they are. I can see some of those playing out in the Indian context for people outside these businesses. I'm not saying these businesses will be carved out, but that tape will play. So I think to that extent, I can foresee there has to be a more proactive approach to deal with this issue. But I think the big theme, if I was to put it, is there has to be massive digital deployment. The whole interaction on compliance it's just part of, it's built into this operating procedures in the company.
Thank you very much, Shiva. That was very compelling, and I think it was important to be said as well. Amar, the fact is, large organizations may have the expertise and resources to respond to risks and ensure adherence to the compliance requirements of COVID-19 and even beyond. Now, how do you see these regulatory requirements putting huge demands on small and medium enterprises? What would be your guidance or even reflections on how they need to work towards achieving compliance and utilize this as a means to build resilience and enable business continuity as well? Even in your own financial sector, what is it that smaller enterprises and medium enterprises need to do?
So, Rajiv, be it a SME sector or any large sector, today everybody wants to be on the right side of the law. Nobody wants to face the regulator. Nobody wants to undergo a whole process of investigation and the potential penalty that may be levied, the imprisonment that may happen. some of the changes that the Companies Act 2013 has brought in. There are a lot of provisions relating to imprisonment. The laws are very, very stringent. SFIO, EOW, you see FEMA. I mean, there is a whole lot of regulators who have become super active in last 1 to 2 years. Auditors, I mean, last 1.5 years, we have seen how auditors have been penalized. Some large scale scams and auditors being penalized. So be it a small scale industry or a large scale industry, compliance is something which is on top of the mind, and it should be on top of the mind of all the management. Any non-compliance will have serious repercussions on the business. I will not hesitate to say that any such SMEs should hire a good legal counsel if they really want to have compliance. And technology is something which is at the helm of affairs, should be at the top of it. And I read a beautiful line today which said that accept artificial intelligence with natural love. So artificial intelligence is something which we all should get into it, be it a lawyer or any other business professional, and we should accept artificial intelligence as the new norm.
Thank you so much, Amar. Much appreciate that. We are live on Facebook and YouTube. Very shortly, I will be taking questions from the audience, and please feel free to send it as soon as you can. Let me move to Mohit. Mohit, I want, in our country, generally in India, the dependence on criminal law and criminal litigation, including law enforcement mechanisms defined by the criminal justice process, is quite liberally used at multiple levels. Now, the question that I have for you is that when you look at European and other experiences, there's a lot of reliance on law and economic analysis when it comes to really even seeking compliances, or for that matter, imposing punishment. Still, you think that we can move in that direction, particularly with regard to making compliances within the regulatory context more with regard to financial penalties and other forms of.
There's definitely a compelling case for that, and there's no gainsaying the fact that whenever you look at consequences, what does make sense from a commercial point of view, not just because it's commercial and easy to just pay off a sum of money, but effectively from the perspective of learn your lesson, pay up, move on, and implement processes that make sure that the same lapses or similar lapses don't recur. From a commercial world point of view, that makes a lot of sense. But I think, to the question that you asked, sir, and to the comments that Amar and Shubham made, I think a lot of what compliance means essentially is mindset. And unless that mindset permeates to beyond, this is the legal department's problem, this is not my problem, you will never quite have constituencies appreciate and understand what it means to be compliant. And I think that's, over the years, I think that's one of possibly the biggest challenges and struggles for legal functions and general counsels has been this approach saying, I am an engineer, this is my domain. I am a salesperson, this is my domain. That's a legal problem, you go deal with it. They say, no, I can't deal with it independent review. You're part of the problem, you're part of the solution. So you work with me. And I think over the last few years, the concept of enterprise risk management frameworks that has been built into global risk management frameworks, and which have gone on to define responsibilities very clearly in terms of the fact that if you're the front runner, if you're the face of the organization, responsibility for compliance, responsibility for managing everything end to end in terms of risks is your responsibility. The legal function, as an example, can help you, advise you, support you, but you're responsible. Unless that permeates, you have a big challenge in terms of what compliance means generally for people. The second aspect is, yes, once you have that understanding, you will appreciate what a legal penalty, what a financial penalty means, and you will deal with it seriously. The flip side to that is, oh, somebody would say, oh, it's just a question of a payment of a fine, we can carry on as before. No, you can't carry on as before. Once you pay a fine, there's a consequence to it. The problem with coming to that point is the ability of the government and the regulator to appreciate that a financial penalty means something. Because otherwise you will deal with exactly what you described. At very, very minor levels of infractions, you have criminal proceedings which lead to either the question of imprisonment or fine or both. And what people are now beginning to appreciate is the fact that if you pay a fine of 10,000 rupees, be mindful that it's not a question of a payment of 10,000 rupees as a fine. It's a question of you having been subjected to a criminal proceeding. And that has an impact for you as an individual. For example, when you're looking to apply, say, for a licensed role or a regulated role, and you make disclosures to say, have you been subject to a criminal proceeding? And you will have to say yes. And that could impact your ability to take on a licensed or a registered role. The second aspect is when you're applying for visas for international travel, even for business, you have disclosures in terms of criminal proceedings. And if you say yes, you could then turn back to the legal function and say, oh, but this was not my problem. This was not my fault. This is what the company did. And yes, I was made party to the proceeding and I had to pay a fine, but it was not my fault. The question is, do you appreciate the fact that it happened? And if you were more careful, it wouldn't have happened. But the consequence visits you in more ways than you really appreciate. And maybe that's something that when you talk about the weighing the benefits of financial penalty vis-a-vis criminal proceedings that lead to a fine, perhaps the government could be looking at it from this lens to say also, is it commensurate? And do you really need a criminal proceeding to lead to a fine in order to drive the message home? Or could you just rest with a financial penalty and not make it criminal? So it's a balance between how people appreciate these things and understand these things and therefore are willing to be compliant. And on the other side, the government basically relooking at a host of these requirements which basically do not allow you to pay a penalty and be done with it, but you have to go through the rigor of the criminal proceeding in order to bring an end to the matter. And it is not to our advantage to have that. I would definitely say that's not our advantage as a system to have a whole host of laws across various matters which necessarily need a criminal prosecution for you to pay a fine and a penalty and be done with that subject.
Thank you. Others touched upon is in relation to the impact of the role of the Office of General Counsel. It will be very useful for me to, and I'm sure audience will also be very keen to hear from you, that does this change from sector to sector? In some ways, is it fair to say that some sectors expect the role of the General Counsel more stronger and more involved in day-to-day business decisions and having a stronger regulatory impact, even risk impact, as opposed to some other sectors? You can unmute yourself, Sachita. Yeah.
Can you hear me now?
Yes, yes.
Well, I think, my perception to a general counsel role, what I have seen over years, has undergone drastic change. What was an in-house solicitor role, collecting the papers from one department and passing it on to the law firm, has undergone a change where you are actually a risk manager. When I talk about risk manager, means you are managing the risk of the business. And then you need to know what that business is. Irrespective of sector where you work, unless you don't know how the business is carried on, you won't be able to deliver. Let me give an example. In a soap manufacturing unit, if you do not know how the soap is manufactured, means from oil, hydrogenation, saponification, then you have to add perfume, then you have to put it in a bar form, emboss your trademark, wrap it in a paper, and then it goes out of the factory. In an excise case, if you have to argue the matter or to brief a counsel, you need to know at which point actually the manufacturing is taking place. Similarly, if I go back to, say, service sector, let us say telecom, that how the customer is getting their phone activated or how his top up is digitally being done through switch, how the call is passed on from one aspect to another aspect of an instrument. I think these are technical technologies which you need to understand. So coming back to your point, I think you need to know the business well. Law you are supposed to know, and I expect that a general counsel coming from reputed law universities will have the base ready. Where the difference will come, in my view, in two fronts. What I just explained, knowing and understanding the business, and the second is the understanding of commercial aspects. Whether you sit for a M&A, the valuation, unless you crunch the number, you will find it difficult. And accordingly, your different clauses in the shareholder agreement may get impacted. So overall, I think irrespective of the sector, the general counsel's role has evolved completely in a different paradigm where you are more of a business partner, a business enabler than a legal person, that I can tell. That's the general understanding. Whereas where the commonality will come is the compliance, governance, risk management. Those first principles or basic principles, in my view, is same and uniform across, irrespective of whatever sector. Yes, the sectoral regulation will require you to do more, but sanction, anti-bribery, these are the policies which are globally implemented irrespective of what is the nature of the business. If you say I'm in a manufacturing, you have to, good manufacturing process has to be adopted. Contract labor cannot be deployed in the manufacturing sector where the actual manufacturing being done. These are the principles, compliance level. I'm just talking from the operating perspective, as your question is. Obviously, board governance and other things are the same, irrespective of where you actually function.
Sorry. Thank you very much for that. I really appreciate it. We are now getting into a stage where we'll take up a few questions. I appreciate all of your patience and candor. Listen, maybe this is first question to Shubha. Shubha, while we did talk about data privacy, there are lots of questions. Abhilasha, Mahalakshmi, and many others are asking this, but I'm going to ask you one of them. Given the increased reliance on information technology and artificial intelligence due to remote working arrangements, how can companies be better prepared for possible data privacy and confidentiality concerns, particularly relating to third parties? Sure. Amar, can you hear us? Shua, please. Can you unmute yourself, Shua? Vidyut?
I think, sir, he's...
Relogging?
Yes, sir, yes, sir. He's trying to relog.
Amar, you want to take that question a bit and then we'll...
Can I step in with a couple of points while we wait?
Yeah. Amar, what you want to say, or Mohit?
Maybe both of us.
Why don't you start, Amar?
Yeah. So working from home has definitely posed a lot of challenges, and it's not easy to deal with this scenario. As we discussed, this is an unprecedented situation. Over-the-shoulder monitoring is no more there. the questions of data security is definitely there. Some of the license condition for the OSP providers has been relaxed by the Department of Telecommunications. These are all temporary measures. There is a whole lot of representation made to the Department of Telecommunication to make it permanent. Information security systems are definitely being challenged today. As I said earlier, there is a need to look into what are the possible potential breaches that may happen. What are the ways in which we can build up a good infrastructure system to protect the data, even when the employees are working from home. People are working from their own residence, which doesn't have the same kind of a security system as the office infrastructure would have. So these are the things which will evolve as we progress, but a good lesson to learn from this situation.
Thank you so much, Amar. Shiva, you want to respond? You got the question, I suppose.
Yes, I got the question. Sorry, I had a bit of a problem. No, I think I agree. I think Amar has put all the right points there. So there will be an emphasis on the infrastructure that comes out. I just would like to add one point that I think this whole concept of work from home and which the world is gravitating towards, I don't think it'll replace entirely the way offices function. It's just going to be another way of working. It's not going to be is one or two question. It's not going to be a choice. It's going to be an add-on way to make business.
Thank you so much, Shiva. Mohit, you wanted to add something?
No, all I wanted to say is that yes, it has become the way of working. And there was an initial process whereby people had to figure out quickly what to do, because not everything is necessarily enabled from home. When you look at something that is at this scale. So as Amar pointed out, there are dispensations from the DOT, from the SEZ for people to take away equipment from offices for connectivity from home. But, to the point that Amar made about there's no over-the-shoulder looking anymore, that's become entirely operational. That's just become system-driven. So what organizations, to the degree that it's been possible for them to do, have done is basically extended the office to the house. And therefore your systems, your connectivity, your monitoring, your surveillance, everything, if you're working off a vanilla laptop instead of your controlled desktop from the office, do you have the software that you need to make sure that there is no vulnerability to what you're dealing with when you're working from home is protected. Over these last 3 months, I think organizations have looked at all of these things to make sure it is as secure as is possible from all the things that the organization would have deployed were you working from the office to a situation where you're working from home. But yes, I mean, this is going to be long term. I don't think any organization today in the world is thinking that things are going to go back to the way they used to be pre-pandemic. And everything that organizations will do towards complying with their own obligations in terms of matters like data privacy will translate to work from home environments as well, to the utmost. So that's, I think, what we're going to be looking at in terms of how do you protect against vulnerabilities, whether they're compromises, whether they're leaks, whether they are data privacy issues, anything and everything that needs to be controlled, monitored, protected will happen.
All right. Thank you, Mohit, for that. Sure, there are questions. I think several of you can answer this. Several of our students, not just from Jindal, but also students who are watching.
Sorry, Raj, I could not hear you at all.
Can you hear me now? Sorry.
Now I can hear you. I'm sorry.
My question was that there are several students who are watching across the country. And one of the things they're asking is that, this whole COVID-19 situation, to what extent it might have a potential bearing on their own careers as well.
Let me deal with that. I know we are running short on time. So Raj, I think I wanted to talk about this. I think a lot of the discussions we've been having, if you ask the role of the general counsel, it is actually the role of lawyers. Actually, that's what's changing. It's not about the general counsel alone. So what are we learning? What are the big themes coming up in the conversation today? Shashwat says you need to have very clear understanding of business, right? That's absolutely correct point. Compliances are more linked to businesses. What was Mohit's theme? It has to be a company culture. It has to be people in operations adopting compliance. So all this goes to me a big point, which is for you, Raj, actually, more than for us. We are we've crossed that point. I think a lot of us, I would dare say, a lot of us, me certainly, I think we sometimes feel we are unfit. And I'll put myself there because I think if you ask me, the lawyer of tomorrow has to be dual qualified. I think that's the change India needs to see, where I think for somebody to say, if I could redo my life, for me to say I'm only a lawyer, I think I'm significantly less well-positioned than had I been dual qualified. It could be medicine, it could be engineering, it could be something which will give you a better grip on those business issues. I would make that the point. I think that's the big theme that students and you in particular should carry forward in terms of your university.
Thank you very much, Shubha. Let's take that question, and that's probably my last question to all of you, and I'll build on that, which is the question about, for all the law students who are watching this, what would you like to tell them as they experience the uncertainty of the crisis along with the studies in law school? How will the current pandemic impact their future careers? We just had Shubha talk about it. How should the students aspire to see themselves in legal careers, in corporate organizations, mold themselves to be more relevant, not just during these times, but also in the future? Let me get that question around, starting with Amar.
So, Razi, so McKinsey came out with a report in February 2020, and they studied some 700 occupations in US, and they tried to analyze what percentage of their work activities could be automated by the use of technology. And then they said that 23% of the work being done by lawyers will be automated by the use of technology. So for all my young law colleagues, the simple mantra is adopt technology. They use this period of COVID-19, which hopefully you will see it. You are seeing it for the first time in your life, and this will be the last opportunity that you are seeing it. Use this opportunity to get accustomed to technology, the digital world. Nobody had imagined that Supreme Court will be working virtually. Today, Supreme Court is working virtually. There are matters, there are petitions which are being worked. Lawyers will not adapted to virtual court hearings. Today, lawyers are appearing before the courts through virtual means. So these are the changes. People are adapting to these changes. Our young law colleagues are much better than what we were in terms of the digital world that they are accustomed to. My only mantra will be adopt technology, be flexible, be observant, and learn.
Thank you so much, Amar. Mohit.
I think I definitely echo that. Technology is something that is very, very relevant and will be increasingly relevant in the future. Lots of people say many jobs will be eliminated, but I think the promise of that is that jobs will also upskill. And therefore, that's the other thing that people have to constantly keep in mind. You need to keep refreshing, renewing, and upskilling yourself. The third element, of course, is you have to be relevant. Of course, upskilling and refreshing and renewing is part of that relevance. But equally to the point that Shashwata made, Shubha made, is that you have to be relevant to the business from a commercial point of view. So what you deal with in terms of the domain that you are facing off to, you have to make sure that you are relevant there, you know what's happening, and you can be a partner. From the uncertainty point of view, I think we live in a world where we're already told that the people who are coming out of schools today will not do any one job in their lives. They will do multiple things. And it only goes back again to how you stay relevant, how you upskill yourself to face any opportunity that comes your way, because you will be dealing with a very constantly and fast moving, life as you go forward. It's not going to be steady state. So the more you are willing to embrace that challenge, the better you will adapt.
Hello, are you guys there?
Yes.
Yes, we are there.
Saswata?
Yes.
We're here.
Yeah. Can you hear me?
Yeah, Shashwata, you can be heard. You can carry on.
Amar, are you there?
Yeah.
I'm there. I'm there.
Okay.
I can hear you, Raji, but we can't see you, but we can hear you.
Let me continue in the interest of time. I think today's generation law school students, whatever I have interacted either in the campus recruitment or summer training, what we offer, they are far, far intelligent than us. They are much more tech savvy, and I don't think technology is a constraint for them. I think this is an opportunity for them to go for online courses, use their technological skill to learn more as much as possible. And my only one advice will be clear the first principle of law very well. If you are well founded on your first principle, and then as Subha has said, that you need to have the second course or second discipline or any other add-on qualification, let me tell you this law will help, because anything is based on contract, and hence I would say that have your first principle very clear and then decide the second course, either management or any other related subject, maybe chartered accountant or maybe something else, which would be supplementing your qualification. That's the way to go.
Excellent. Well, can we have, Mohit, you already said it, right? I briefly missed what you said. So, Mohit?
Yes, no, I've spoken. I've spoken. Basically, I said that you need to make sure that you keep upskilling yourself,
Right,
refreshing yourself, renewing yourself, and be relevant to your business domain. Yeah.
Okay, excellent. Well, great. Shiva, you have the last word.
No, I thought I did speak about it. I think we all have consensus on this topic that the younger generations have a great opportunity here. Although I do believe that the conventional law fields has been in India, for example, corporate law, the M&A law, are going to see, if I mean, the graph won't be so steep as it grows up. These are going to flatten or probably go south. The areas where I think there will be a fantastic growth for lawyers if they had to make their career choices, it would be in areas such as regulatory, be it telecom regulatory, electricity, or antitrust. And of course, the favorite, litigation. I think we're going to see the world more of disputes and more of regulatory challenges. So if I had to summarize the big themes, these I would say are the big themes of the next 10 years.
Thank you very much to all of you. Listen, I really want to appreciate Shiva, Amar, Mohit, as well as Saswata for your time. We couldn't have had a better group of general counsels who had vast and distinguished experience reflect about the role of the Office of General Counsel, but also how you are responding to this crisis. I also thank all the audience who are present here. Sorry, we couldn't take more questions than we did, but we deeply appreciate your presence. I want to thank Live Law, our thought leadership partner in this. I look forward to seeing all of you back on Saturday, when we will have a distinguished Indian Jurist Colloquium on the future of law, justice, and institutions, India's tryst with destiny and democracy. We have Professor Upendra Bakshi, Professor of Law at Jindal Global Law School, Professor MP Singh, also a Professor of Law at Jindal Global Law School, Professor B.S. Chimney, Professor of Law at Jindal Global Law School, Professor B.B. Pandey, Professor of Law at Jindal Global Law School, and Professor Dr. Amita Danda, Professor of Law at Nalsa University of Law, Hyderabad. We will meet again on Saturday, 27th at 6:30 p.m. Till such time, thank you very much for being present here, and deeply appreciate all of your time and indeed your candid observations during the course of this colloquium. Thank you.
Thank you.
Thank you.
Thank you all.
Thank you. Pleasure.